There's no hotter topic in the whole discussion about Me Too and harassment than arbitration as a way to resolve harassment claims and disputes. It is a subject of legislation in a number of states to restrict or prohibit employers from using arbitration in harassment disputes. You have probably seen large, high-profile companies come out and say they're no longer going to use arbitration as a way to resolve those disputes. And in the legal business, law firms who have arbitration clauses, say with summer associates or associates, come under some pressure to quit doing that. So do you know what this really is about and what arbitration is and what it means? So very simply, arbitration is an alternative form of dispute resolution, an alternative to litigation. Not a new topic. It's been around for a long time, particularly in unionized settings is one very common place where arbitrations are the historical way to resolve many employment disputes in lots of companies, anything under the union contract. It is not public. And I think that's one of the reasons that it has become popular in the Me Too discussion, which is, if it's private, is it a way for companies to cover up bad actors? It also has been viewed in the recent discussion as pro-employer. I don't really think it is, personally. We've been talking with employers long before Me Too with the question, hey, should we have an arbitration clause? Should we use arbitration as a way to resolve all kinds of employment disputes? And the dialogue we've had with clients for literally decades has not been focused around the idea that arbitration is more likely to result in a good result for employers. In fact, arbitrations among employment lawyers are known for splitting the baby, and sometimes that's not really desirable. Usually the conversation has been around, is arbitration cheaper and faster? And you can have different discussions about that. So it's somewhat surprising, I think, for those of us who've been doing this a long time, that it's now viewed as pro-employer, because that's historically not how we've talked about it with employers. So I don't agree with that premise, but it's clearly a hot topic people ought to be familiar with and ought to understand. In my view, the most effective way to address harassment in the workplace is to find more opportunities to address small problems at a lower level, engage in group problem solving, and create ongoing awareness of what people are comfortable with and what they're not, and have open communication about that. But right now, arbitration gets a lot more attention than that.